And the first speaker is Natalie Byrom. So Dr. Byrom is Honorary Senior Research Fellow at University College London. Here she is, very welcome. Her research focuses on evaluating the impact of data-driven technologies on access to justice and mechanisms for increasing public publication in justice data governance. I hope you have read her very well written and insightful paper, and she's now going to give a wrap-up or an introduction of 10 minutes to that paper. Most welcome. The floor is yours.
Fantastic. I'm so sorry. Well, it wouldn't be, I mean, this is just perfect illustration of the many challenges of computational tools. So I'll restart if I may. It is such a pleasure to be here today, and I'm only sorry that I can't be with you in person. I wanted to start by extending my huge thanks to the wider Cohubical team for their excellent work, which shines a light on what has been really a neglected issue within wider AI debates, at least in the UK. I also want to thank the organisers for inviting me to speak today. I feel especially privileged given that I'm not a computer scientist or a legal philosopher. My background is as a social scientist and a policy advisor, and much of my role over the past 5 years has been working to advise policymakers who are implementing data-driven technologies and designing data-sharing policy for the public justice system in England and Wales. And within this, my particular focus has been on how we can ensure that the development and deployment of computational technologies advances rather than undermines access to justice. So I was asked today to give my perspective on the development of the field of computational law, and in particular on what needs to happen to ensure that this work develops to support rather than to undermine rule of law values. In the 10 minutes that I have with you today, I hope to convince you that the development of the field of computational law is at present undermined by an impoverished understanding at both a theoretical and an empirical level of what access to justice is and what it isn't, and that in the absence of a theoretical and empirical grounding, the access to justice problem is too frequently treated as being synonymous with the need to make justice systems cheaper, primarily for those who run them, by either encouraging people to resolve their disputes outside of the formal legal system, or by integrating data-driven decision-making tools into the formal justice system to help reach decisions faster in certain categories of claim. And that this focus on cost reduction is driving both the types of computational tools that policymakers are interested in, and therefore funders, and the types of cases that these tools are trained on, closing out space for broader normative considerations. And that this taken together poses a threat to the rule of law, public trust and confidence in the justice system at a time when it's already fragile. I want to leave you by suggesting that as part of the approach to resisting this, as well as focusing on the evaluation guardrails that look at the veracity of claims made by the providers of these tools, the field of computational law needs to be alive to the impact of the adoption of computational tools and technologies on the right of access to justice, and developed and adopt evaluation frameworks that measure the impact of these tools on this right as a whole in the real world. So firstly, I want to start by saying, what do we mean by access to justice? Now, access to justice has been described as being inherently ambiguous, including by judges, which is slightly worrying, but also by policymakers. So until 2019, for example, the UK Court Service did not have a working definition of access to justice with key performance indicators attached to it, despite the fact that the obligation to uphold access to justice is written into its statutory objectives. But if you look at the existing case law, a clear definition that's capable of being operationalised as an empirical standard emerges. So under this definition established in case law, access to justice means that all individuals in a full run of cases are able to access the formal mechanisms of redress provided by the state, so courts, tribunals, ombudsman schemes, and court annex mediation, access a fair and effective hearing, access a decision in accordance with law, and crucially, access the outcome of that decision, so the remedy of that, on an equal basis. Now, the components of this definition are mutually reinforcing and indivisible, which is a fancy way of saying that if you increase the number of people who enter the formal legal system, but fail to ensure that they receive a fair and effective hearing with appropriate controls for equality of arms, or secure the increase of number of people who receive a decision in accordance with law, but don't ensure that they're able to access the outcome of that decision, you have an increased access to justice. And the historic failure to cohere around a definition of access to justice that's theoretically grounded and empirically verifiable has had profound implications for our ability to ensure access to justice in the real world. It means that we lack the data to routinely assess and monitor the challenges that people face in securing the right. And it means that we misunderstand the scale of the challenges we do know about. See examples from existing research here. For this reason, access to justice has been fairly described as a principle that's both widely embraced and routinely violated, but in ways in which we are unable to fully comprehend and therefore address. Now, in the face of this dearth of empirical and theoretical clarity, the access to justice challenge is increasingly being rebranded as the need to reduce the cost of the existing justice system, as I said earlier, either by encouraging people to resolve their disputes outside of the formal legal system, and that's driving some of the interesting case outcome predictive tools on the idea that that would encourage parties to settle before they ever reach court, or integrating data-driven decision-making tools into the formal justice system to help reach decisions faster in certain categories of claim. And this development's being matched by a worrying lack of concern about whether those decisions, which will still be rendered and sponsored by the formal justice system, are actually in accordance with law. You can see from this quote here from the judge who is actually the head of civil justice in England and Wales, that this right enough, good enough for some people rhetoric is coming to dominate debates on this topic. Now, this right enough, good enough rhetoric, combined with a focus on efficiency, but by what is really meant cost reduction, has two important implications for the development of the field of computational law. Firstly, it drives interest in certain kinds of data-driven technologies and approaches, those that are cheaper and those that don't require structured data, so not the type of argumentation-driven tools that Denis will speak about later in this panel. And secondly, the selection of those types of technologies on the grounds of reducing cost also predetermines the types of cases that will be resolved using these disputes, high volume cases. And this is really worrying because it's the high volume parts of the justice system that some of the most acute imbalances of power between parties exist. So things like employment, immigration, welfare benefits, housing. This has huge implications for the types of outcomes that data-driven tools, which are based on patterns in historic data sets, will reach or recommend. Now, policymakers and judges, when faced with concerns or objections raised on ethical grounds to proposed changes, often talk about excluding certain types of cases from data-driven decision-making on a normative or ethical basis. But the framing of the problem, that the justice system is too expensive, and therefore the solution, that what is needed is cheaper decisions delivered by data-driven tools, predetermines the types of cases that these technologies will be used for, closing out space for normative considerations. And if we wanted evidence that cost considerations are likely to prove definitive when it comes to the adoption of these technologies by the state, we need only look to the recent history of our digital court reform programme in England and Wales. Now, when this court reform programme was announced, which was intended to create fully online end-to-end digital processes for resolving disputes, one of the key proposals was the creation of a solution finder that would act as the front end to the court based on a decision tree model built around the example that's provided by the Civil Resolution Tribunal in British Columbia. It was described by the judge who pioneered the digital court reform programme as the only part of the online court programme that represented an access to justice solution, but it was quickly abandoned due to the cost and complexity of building this. This rebranding of the solution to the access to justice crisis as one of reducing the cost of the system, therefore poses a really key threat to both the rule of law and public trust and confidence in the justice system at a time when it's already fragile. So In order to resist this, the field has already begun to coalesce around evaluation guardrails that look at the veracity of claims made by providers of these tools. And this work is vital, and it must be encouraged and also widely disseminated in a way that policymakers can engage with it. In addition to this, the field of computational law needs to coalesce around a definition of access to justice at a system level and be alive to the impact of the adoption of technologies and tools on the right of access to justice, and develop and adopt evaluation frameworks that measure the impact of tools on this right as a whole. So not just do these tools work in their own terms, but what is their impact on the wider right of access to justice? Thank you very much.
The floor is yours, Denis Merigoux, for the reply.
Sorry about the mic. Thank you, Mireille. Thank you, everyone. And thank you, Natalie, for your paper, which I really much enjoyed reading. I thank you for opening up the paper with the very illustrative example of a Wabi shack that reminds us of what the actual consequences are for people who lack access to the justice system. Of course, those kind of heavy consequences can have dire impacts on the life of people. And on a lighter note, I was also personally subject to an issue on the access to the justice system because I was part of an association that filed a complaint against the building permits, and then I realized there is a law in French law that your association needs to be created 1 year before the building permit exists, before being able to contest it. So, and this is when I realized myself how even the formal requirement to access the justice systems can be sometimes completely backwards. But of course, this is way less important than the problem that Natalie is talking about. I want to come back on a few of the arguments that Natalie makes on her paper. And try to add some clarifications or additions to the argument she makes. And then I'll conclude about a statement about the arm race that is coming about in the legal technology space. So first, in paragraph 2.1.2, Natalie insists on the piecemeal development and evaluation of tools that are brought about by the field of AI in law and legal technologies. And this comes back to points that is being made repeatedly by a lot of the speakers here, which is the evaluation crisis of the domain. And yes, of course, we should take into account all the stages that Natalie describes in her paper about access to justice, instead of focusing to only one part and claiming that solving this one part will have only beneficial impacts to the whole system. And to that end, I would really encourage people developing tools for legal professionals to actually meet their users and see their users in the process of their daily practice. Because if you don't do this step of going to do a field inquiry, basically, to see concretely what your users are doing, how they will use your tool in the broader context of the whole chain of events that Natalie describes so well in her paper, you will miss things, and you will enter maybe with good intentions, but end up doing something which have bad consequences. And so this is a very pinpoint and accurate emphasis that Natalie makes in her paper. The paragraph 2.1.3 stresses the need for an explicit focus on right realization for tools in the legal technology space. And for that agreement, I also agree, because there's this cost-cutting discourse that's being really dominant in the space of mostly, I would say, public administrations, because usually public administrations have the most emphasis on cutting costs these days rather than companies. But then I want also to warn against kind of a vicious effect of that explicit focus on rights realization, because sometimes you can combine an explicit focus on rights realization and the cost-cutting approach. This point is made by a French researcher called Clara Deville in her PhD thesis, which was published in 2020, about the way the French Benefits Administration, the CAF, tackled the problem of non-recourses to rights by people that could apply for French social benefits, which basically didn't. And there was this whole discourse when the left was in power in France with François Hollande in 2012, saying, oh, we should fight that phenomenon and how we're going to fight it, etc. But there was this explicit goal of trying to solve that problem, but at the same time, they didn't want to increase too much the budget or put real means behind it. And then there was this unholy alliance because the administration of CAF said, okay, well, we want to fight that problem too, but we think the solution to this problem is to digitize all applications to social benefits, because it will be more accessible, we can have more controls and feedback about the applications, and overall it will help people access the benefits that they're entitled to. Of course, the end result of those policies was not completely aligned with this goal. So, which is why I want to also warn against some kind of access to rights washing that may be present in the rhetorics of, okay, we will increase the access to rights and to justice, but with technological means. I mean, usually the main solution to access people's rights to justice is simply to maybe have more human mediation, but which is very costly. So if you see a plan where all the impacts, expected impact of the access to justice is done purely through technological measures, then perhaps that's an indicator that something else is going on. The point Natalie makes in paragraph 3 regarding the values driving the developments of the field of computational law is something that I will talk in depth later, right? Because the ideologies that are driving the designers and the implementers of the systems may not well be ideologies that align well with increased access to justice. And perhaps because there's this kind of blind spot in the conception of law that, oh, law is kind of, if you have a dispute, then it's kind of like a gentleman's dispute. Okay, everybody is like, it's a minor problem and we can all settle it reasonably, but actually most of the cases, the high volume cases that Natalie talks about and that want to be automated are like almost life and death cases, and she really puts that point forward in an article of the case of Awabi Shak, right? And so when your life or your financial health is at risk in your case, you're not going to approach the rational debate with the same mindset as you were if this were just like an on-the-side dispute for something you don't really care about. And the blind spot of the political fights and the power struggles and how law is an instrument in those power struggles is something that maybe Natalie hints at in her paper, but which I want to make more explicit, because I mean, you have to, in some battles, you have to choose your side, and declaring that, oh, I don't see the battle is may not be the solution that will really make the things go forward. Then there's the point about the arms race that Natalie makes in her paper, which is kind of left out in the presentation, if I've understood correctly, but I want to come back on it, because in paragraph 4.2, she talks about the unequal access to funding to legal tech entrepreneurs by comparing the amount of funding that goes into startups that address big law problems versus startups that address regular people's problems. And I want to frame it, I want to say, yes, of course, this inequality is glaring and this is a problem we should address, but there's a missing actor in that description, which is what about the state, right? Because usually when there are problems of inequalities that are being fueled by the unregulated development of the private sector, then at some point people say, oh, the state should intervene. And the question is how the state should intervene in this problem of access to justice. always reminding us the context that every time there's proposals for state intervention, we say, oh, but we're going to impede innovation and how we're going to lag behind the Chinese, or these sort of arguments. But when you look at the way the legal profession is regulated and the complexity of the law and the ways to remediate the problem of access to justice is a very old problem. That's why the legal aid system was put in place. So I'm talking here about a computer scientist with a very weird understanding on how these things look from the outside. Of course, you may point some inaccuracies in my discourse, which I will be very thankful if you could put forward your questions later. But lawyers are basically allowed to not be civil servants. But on the other hand, they have the obligation to actually help people through the legal aid system. So this is kind of a trade-off, right? So you've made such that lawyers can work in their own interest rather than always in the public interest if they were public servants. But you ask something from them because you recognize that their activity is beneficial to society as a whole, and that the merchants' way in which their services are provided may lead to inequalities. And in the context of the arms race, I would say, okay, couldn't you think of some system for legal technology applications which are distributed commercially, but you would also maybe mandate that their access is free for some kind of lawyers in the legal aid process, for instance? I mean, I don't know. Again, I'm not doing the digital law regulations, and there are more expert people than me than this. But I think this is this kind of concrete talk that I may be missing here, and which may be part of the solutions going forward. Even though you have to be careful of the problems like when private industry captures something that the states could, do more efficiently. And this is the problem with filing taxes in the US, for instance, where people submit the form, but rather than only declaring the income, they also have to compute themselves the amount of tax they owe to the government, which is completely inefficient. So private sector has come up, and this is a point very accurately made by Sarah Lowski in lots of her presentations. You have to pay a software company for them to actually compute your tax, which is a service governments do in most countries. And then those companies have lobbied Congress to prevent government to actually do that service for free, but then it's changing at the moment. So you also have to be aware of this potential, again, public service washing argument that, we're going to let commercial applications provide this commercial service, but in exchange, we'll have a little token of access to justice that the tool will going to help to provide a free option for something. This also can be an argument put forward to prevent legislation that would lead to a more efficient and equal situation in the end for all.
Thank you very much. Natalie, would you like to respond?
Thank you so much, Dan, and thank you for the thoughtful way you engaged with the paper. I mean, it's very difficult to disagree with anything that you've said, really. I mean, I think you're exactly right on this kind of mischaracterization of legal disputes as being between equal parties where there's and I think one of the things that's really frustrating about the debate is that this term that's been adopted in the UK a lot, this idea that digital technologies are fine for the high volume, low economic value cases, really elides the fact that if you are, it might look a low amount of money. Like if you think about employment tribunals, some of the biggest barriers that we have relate to people who are on the lowest wages being able to secure them. And if you think about the absolute amounts of money involved, then yes, compared to other disputes, they look minor, but the significance of that to someone's life, livelihood, abilities to sustain, their income, abilities to sustain their accommodation even, it might be low value, but it's high impact on the person. And the way we talk about which cases matter and which don't obscures some of that and definitely flattens this huge power differentials, which after all, that's the point of the legal system. The legal system is meant to help address, not exacerbate, those power differentials. And by failing to acknowledge that they exist, we're obviously setting ourselves up to develop tools that are going to perpetuate rather than address them. So I think that's completely valid and bang on. I totally agree. It's really difficult, isn't it, on the point about would we feel happier if companies that were developing these tools were kind of open sourcing them for use by smaller law firms, legal aid practices. I think one of the challenges is making sure that the tools that are kind of relevant for firms that operate in areas outside of legal aid would actually be of relevance to legal aid lawyers in their day-to-day practice. And I totally agree with you also on the risk of kind of like ethics washing the industry. And I suppose, given reading so many of the other excellent papers, including your own, given that we're so worried about the ability of tools that we have at present to even do the things that they say they can do within a context where you've got kind of rich data and resources, it makes it particularly frightening when you think about transposing that to the context of legal aid, where there's such poor data and such lack of funding for infrastructure. And I mean, by infrastructure, I mean like basic computers and computing programs. There's huge sort of structural inequalities in the tools and technology that are available to the part of the profession that serves people on low incomes versus counterparts. Overall, I thought, your comments were extremely prescient. I don't fully have the answer for how the state should intervene. I think in England and Wales, one of the things that was done was the government set up this sort of challenge fund. And the idea was, how can we provide funding to law tech firms who are delivering products kind of that are geared at access to justice? And it was framed a kind of like a mission-focused challenge. But the problem was, because we've so systematically underinvested in the data, the capabilities of the organizations working in that part of the profession, their ability to capture and engage and meaningfully dictate the development of those tools, it was really marginal. And in the end, I think I may have mentioned this in the paper, but less than 1% of the funding that was allocated to go towards the deployment of legal tech tools in that space actually ended up going to firms that actually serve those communities. So it definitely is broken, and there's definitely really limited kind of appetite or recognition from the state about the kind of need to intervene. So all of which is to say, thank you very much for your kind of thoughtful comments, and really excited to continue the conversation.
Yeah, we have a few minutes more. So later this afternoon, I don't know whether you had the time, but Gian Claudio Malghieri and Frank Pasquale will present a paper where they are suggesting to use generative AI to assert applications for social benefits. I'm shortcutting the paper. That are prima facie according to that particular type of generative AI, and to not keep them waiting. So it's sort of an invert. Did you read the paper? No. You had no chance to read the paper, perhaps. No. So the idea is to turn the tables and to turn the burden of proof around in a way, using this technology for decisions that are beneficial. So there is a problem of scaling. If you're going to deal with all these applications with human beings, then by the time the benefit comes to that person, they may have already been thrown out of their house. This is specifically, I think, the kind of problems you're talking about. And here the idea is to give the benefit of the doubt based on a generative AI analysis of the application. Now, I'm very curious about your response to this. Would this solve the problem? Which problem would it solve? Would it create new problems? Which new problems? And on top of all these questions, I also would hope that you can answer them in 2 minutes. we can come back to them at the end of all the panels in this, of all the speakers in this panel, but just a quick response.
We actually have a directly analogous example that's already happened in the UK. So the EU settled status scheme, when we made the disastrous decision to exit the European Union, one of the key things that government was really interested in is how do we make sure that EU citizens are able to apply for indefinite leave to remain. And they were really interested in how do you use technology at scale in order to deal with those applications. And so what they decided to use, it wasn't generative AI based, but it was basically data matching from sort of administrative records to try and make sure, and the incentives around that scheme were positive, right? It wasn't like in welfare benefits administration, where often the incentives in our jurisdiction at least have been to restrict people's access to benefits. We've got a very kind of punitive approach to access to welfare benefits. It was actually a case where the incentive structures were positives. It was about rights realization. But the way in which that was executed actually served to really marginalize and exclude people because it wasn't properly thought through. And the reason for this, so for example, if you were in a care home, if you were a woman who'd had a child and you didn't have a record in tax credits, then your basically what it found was that people were not being given the secured status that they were entitled to because they were missing from the data and missing from the information. And it was a really clear example of where often the use of digital technologies, we're trying to build these tools on top of data that is a mess and that is gappy and that is replete with biases. And there's one of the big frustrations in my work has been the limited appetite of policymakers to recognize this and fix the problem before building in technological solutions. So what I would say is, yes, incentives matter, and they matter a lot. If you're trying to do something positive for people, that's sort of inherently obviously better than when you're trying to restrict rights to people. But I think there's a whole range of things that need to be thought through in that case. And it's particularly difficult when you're operating in these systems where we've had historically lack of attention paid to infrastructure. But yeah, I'd love to discuss further later. Thank you so much for the question.
If you prioritize certain people, or if you assert certain people and give them benefits, that also means you're not doing that for others, because otherwise you might as well agree with every application, and that's not the idea, of course. So prioritizing some necessarily means disprioritizing others, and I'm a bit worried that who are going to be those others and will not resurface exactly what you're saying. And what I very much appreciate in the paper and in your responses and in your presentation is the precision with which you show that this is also a matter of data collection strategy. Whether deliberate or not, the right data is not there, and that is going to skew decisions that are made. Okay. Thank you very much. I hope you will remain with us throughout the panel. Thank you. And that means I'm now going to give the floor to Denis Merigoux, who is an editor of the journal, like many people here, but not all speakers. I'm going to be precise about introducing him. So he's a researcher at INRIA in Paris inside the Prosecco team. We all want to be in that team. Specialized in the study and design of programming languages, domain-specific programming languages, I think, and formal verification. And the floor is yours. Thank you very much.
Thank you. Wow. I even have my slides. Is there a button for the next slide thing, or? It's amazing. No, I don't think it works. Oh yes, wow, oh, okay. Thank you very much. Such technology is impressive. So today, I want us to kind of expand our horizon from the regular audience that attends this conference. Maybe some of you were here last year, and take a tour of the historical intersection of law and computer science, which has been kind of dominated by the AI in Law conference. So we're talking about the AI in Law journal, conferences like ICAL, JERX, etc., etc. And this is the field to which I was introduced after my initial training, which was in a completely different area of computer science. And initially, when I arrived at the domain, I said, "Wow, I mean, I'm from CS. I want to develop applications for the legal domain, and does this mean that I will have to do AI, right?" And I mean, I'm not really an AI person. I would kind of define. I would kind of define the actions which I do as developing tools to enhance human intelligence, you know. But then this was AI in Law, so I had to look at what they were doing and try to see how my contribution would fit to the field. And then immediately I was reading some of the founding documents issued by the leading researchers of the scholars of the centers that were doing this kind of computational law, and I found things like this. You're walking through the woods of Maine, you see an attractive flower, you take a photo with your iPhone, the plant app identifies it as a type of orchid and lets you know. At the same time, the legal app tells you that you can actually pick it, or you can't pick it. And this is an excerpt from the computational law called A Cop in the Backseat paper by Michael Gnesaret. That is one of the founding documents of the Stanford Codex Research Center in AI in Law. And this actually struck me because I was, okay, this is not the kind of legal applications I wanted, but apparently this is the kind of things that are pursued in the domain, and this really bothered me. So recently, I was prompted by the Cohibical Research Group to kind of engage with the AI in Law community and what they have done. And there's a recent presentation in the broader AI domain by Timnit Gebru and Emil Torres about the underlying ideologies of AI research. I mean, not all of AI research, but some of the prominent figures that benefits from a lot of funding. And so the arguments of Gebru and Torres is that basically these leading people at the Existential Risk Center, etc., are pursuing some form of the ideology that is basically derived from 20th century eugenics. And I was like, wow, this is pretty bad. But apparently this describes a lot of the focus of the field of AI, and especially the quest towards the artificial general intelligence and all the utopia benefits that it will unlock. And I was reflecting to myself, of course, AI in Law doesn't go as far as this kind of AI quest for artificial general intelligence, but there is some parallel about how ideologies can shape the research field and how they shape not only the questions that the research field wants to answer, but the technological solutions it chooses in order to advance on building those solutions. So definitely the AI in Law community has kind of a techno-solutionist and techno-optimist bias, right? I mean, this is an assumed bias. Some of them are very explicit. Here you can see the same paper, Michael Gnesaret, being very explicit about the techno-solutionist aspect of the line of research he promotes. But in other papers, this is kind of more subtle to detect, but there's this kind of a broad tendency that, okay, we're going to bring technical solutions. But technical solutions to what problems, actually? And not all AI in Law papers clearly state the legal problem they want to tackle. So you have to dig a little bit more to see which is actually the problem that they want to tackle. There is a connection between the AI and the law community because, as put forward by dissertation in 2003, the focus of the intersection between AI and law has been to kind of represent legal knowledge, and this has been their explicit goal. We want to represent legal knowledge, so we want to have a formal representation, basically, of everything that touches to legal domain, so that we can analyze it and answer questions and basically do all kinds of computer processing on this. And as you may have noticed, what the law is first and what the law touches first, second, are basically over everything. So it is actually a very general objective that they want to represent. And this is why the intersection of knowledge representation and legal knowledge representation basically amount to the same thing, because if you can represent legal knowledge, you can basically represent everything. And then what do they want to do with all these models that they're building? Some of them, so the questions of should we replace judges has already been posed in the past. Some AI and law scholars are really upfront about that and say, oh, we don't want to do that. And so Lucien Mel, for instance, a French state counselor, was very clear about that. But sometimes, you know, they say, okay, we don't want to do that, and then 10 years later, somebody asks the questions again, and then there's a cycle of always, oh, we want to replace judges, yes we can, no we can't, but then the questions keeps coming back. And usually there's this kind of debate and switch thing that was really accurately put forward this morning. It's to say, okay, basically are the uses for our legal representation model are only to inform and teach and analyze things. But then there's a switch, so then, okay, but we can actually decide things with them. And then whenever it doesn't work, you say, oh, this was just for informational purposes. So I really see this put forward. And when you look at the mission statements in AI and law community, there's always this back and forth that is difficult to follow, and that's very confusion-inducing. Another problem which the AI in law community has been trying to solve for a long time is the help to legal drafting. And nowadays this is being taken very seriously by the OECD or bodies like the European Commission putting forward some digital ready legislation. There's even an agency, a government agency for that in Denmark. And we see that as this idea is taken more and more seriously, the shift from, oh, we're just a tool for analysis, it's become more and more a tool for constraining how law should be made. And this is a typical example of the dual use of the technologies that we can use, that are being put forward, is that you can either use them in a very benign way, but without changing the underlying technological artifact, you can also use it for more constraining things. And this is potentially dangerous developments. And then there's this, yeah, 1 minute, okay, I'm going to switch a lot of these things. So then behind those mission statements, there are basically two ideologies that are really underlying the AI and law community, as I've documented in the paper, which is that you have legal formalism and cybernetics. And those two really share that objective of we're going to try to make a general model of what legal knowledge is, and then we're going to be able to infinitely reuse that model. And this in order to make society more efficient and to cut on costs, etc., etc. But then this doesn't kind of work in practice, and we're still not seeing the massive industry adoption of all these methods. And this was a 2002 report, a paper that was saying that, and I think we're still in that phase in 2023, even though there have been, of course, some changes. So I'm going to switch that. Of course, you can refer to the paper. But basically, what I claim is that this emphasis, ideologically imposed emphasis of developing infinitely reusable models to model basically everything, and then you can reuse it for every application, tweaks the kind of technological artifacts that are produced with the focus on logic programming or ontologies or literally general purpose LLMs. But all of these technological artifacts have drawbacks because they lack the specific purpose for which we can evaluate them. So it ties with the evaluation crisis that I was mentioning earlier. Usually their application, their success criteria, they always have, oh, but it's going to be inaccurate, or it's going to be lacking proper substantiation on X%. But for some applications, and I claim all the legal applications, a lot of them are in that case, you need 100% correct things. And recognizing that critical aspect is, I think, key in seeing why you really can't have it all, both the infinitely reusable model and the 100 and the perfect track record on the critical applications you want to apply them. And on the last point, I think that those technological artifacts have made the field to spend a lot of time on building massive infrastructure for logic programming, for ontologies, and they're spending years and years and years and years making those models. But the last step in which they meet the users and they actually deploy the outcome of the research has been somewhat lacking. And I think this is a reason why the applied research branch of AI and law can still improve itself and maybe start developing applications that target the real needs of the legal profession rather than something that is ideologically imposed by the designers.
Thank you very much. We are now bringing in online Professor Giovanni Sartor. He is a professor in legal informatics at the University of Bologna, legal informatics and legal theory at the European University Institute in Florence, and many other things. I would say he's one of the founding fathers of, let's say, legal informatics, but even much more than that. Giovanni, the floor is yours.
Okay, thank you very much. Mireille, I hope everything works. It's a pleasure to be with you. I'm sorry that I cannot be with you in person, but I do my best to try to engage by my office in Bologna. I must say that I find interesting things in the paper by Denis, but I do not agree with his main claim. So when I started reading this paper, I thought that the key idea was that it does make not sense to develop formal models of the law. This is a bad idea, and we should devote public money and effort to better purposes. But then when I continued reading, I found that he was suggesting something different, that formal representation of the law should be developed for specific purposes, matching the need of specific kind of user in particular domains, and we should not aim at developing final general purpose computational model of the law which exhaust the content of the law and can be applied in any context for any purpose. And I think that I fully agree with this contention. I've always been claiming that the law must continue to be primarily a human enterprise, which aims to regulate human behavior through directives that humans can understand, have to comply with, or also to check the compliance by others. And this does not exclude that we may study ways in which computer systems may support people in determining how to comply, on how to assess compliance. It does not exclude that we can build logical formal models that try to capture some aspects of legal reasoning, and even that we have AI agents engaging in legally relevant activities. So where do we disagree? I think that I disagree with Denis in his factual contention that AI and law, a large part of AI and law research, or if not most of AI and law research, has taken what he views as the wrong path, be driven by a kind of hubris, overconfidently. It has overconfidently engaged in the attempt to develop such exhaustive and general purpose models of the law. This does not fit my experience within the AI and law community during all those years. Most researchers on AI and law have been aware of this issue. And we need to consider in this regard two different directions of research in AI and law. So there is the trend to build application for some practical purposes, and the idea to build also theoretical approaches and formal models that capture certain aspects of legal reasoning. in continuation with legal theory, at least with analytical legal theory. And there are some application of the symbolic approaches to the law which have had some success. I will only focus on symbolic approaches, even though the focus is on machine learning approaches which are not considered in the paper by Denis, and so I will skip over them, even though now a large part of the AI and law research has moved into the machine learning or sub-symbolic approaches to AI, where there have been some considerable results. But let me focus on the symbolic approaches. There are applications for tax administration that represent in a computable way some aspect of tax law that are useful, for instance, for helping citizens to make their tax returns, or administrators to control tax returns, or in the domain of getting information about benefits, or even for supporting administration in making determination on benefits. There are quite a lot of applications of this kind. Some were originally built using standard computer language, I know in COBOL, or more recently maybe in Python or Java, whatever. And there is also some of these systems have been developed by using rule-based expert systems. There are some companies doing that with some success. This system have not gone successful, as far as I know, into judicial decision making, which I think is good, because when you have this system are good when you have many rules to apply, the application of each one being relatively straightforward. When we have controversial facts or controversial interpretation of rules, they are not the tool to be used. But building application has not been the main focus of AI and law. I think the focus has been in something which comes before building application, that is in trying to provide a formal analysis of aspects of knowledge and reasoning that may enable computational processing of such aspects. So we have attempts to provide new definitions of deontic logic. We still don't have a deontic logic which is good for most applications, to deal with the feasibility, conflicts of rule, analogies, methods for linking goals and values to norms. I think that all these kind of results are useful for building certain kind of applications, even though not many have been successful so far, but also interest for legal theories, for lawyers who wants to better understand certain aspects of legal reasoning and improve their reasoning skills, and also for computer scientists. So if Antoine has no criticism against this kind of special purpose applications, and he has also no criticism against the attempt to provide formal models of certain aspects of legal reasoning, where is the conflict? By a formal model, let me say that I just understand a model where you have well-defined formal languages, and that the output that you can obtain by on the basis of these formal languages, the inferences if you're doing logic, or the outcome if you're using a computer program, are defined according by the semantics of the logic or of the computer program, that is of the computer language that you are using. So it's basically a matter of syntax. Once that you know the syntax of the input, you are able to determine what is the output that you obtain from it. So if this is if Denis has no criticism against this kind of approach to capturing aspects of knowledge in a formal language, what is his criticism of the AI and law domain? And then he says that AI and law is formalistic. I must say that I'm a bit allergic against the word formalistic, because everybody means a different thing when you use this term. I don't know, Kantian ethics is formalistic because it does not tell you what you have to do, but just that you have to comply with a categorical imperative. Kantian idea of law is formalistic. It doesn't tell you what you have to do, but just that you have to respect everybody's freedom. But maybe legal interpretation is formalistic in the sense that an approach to legal interpretation is formalistic in the sense that it is based on the dictionary meaning of words. Is this an aspect of AI and law? I don't think, frankly, I don't think so. In AI and law, there has been a lot of work that has focused on the connection between rules and purposes and values. Very little substantive implementation, but a lot of research in this domain. Another sense in which you may say that a kind of legal reasoning is formalistic is that it assumes that legal concepts have a fixed and undefeasible nature. So that, for instance, every contract establishes obligations, or in AI and law, there has been a lot of work on, for instance, the feasibility, which is the opposite of this kind of formalism. I don't know, you may say that, I don't know, law and economics is formalistic because it just focuses on welfare or the amount of wealth that is obtained, or on individuals and rational decision makers. Is AI law formalistic in this sense? I don't think so, because consideration of values has been taken by various researchers in this domain. And also the teleological reasoning is also something that has been considered by scholars on AI and law, which have also looked, for instance, into aspects such as decision theory and game theory in order to build their formal models. So I think that I may conclude at this point. Frankly, I found many interesting aspects in Denis' paper, but I don't think that his assessment of AI and law research matches the way in which I am able to look at this research from my particular perspective. So thank you very much for your attention.
Giovanni, yes. We're now getting a really animated debate. Agonistic, that's good, that's good. We're not here to preach for our own hurt, and that would be boring. So I'm going to give you the floor first. Yeah.
Thank you, Giovanni, for your really long and characterized and precise answers. And I must say, I'm a consumer of all the theoretical work that you mentioned, because I read the papers, and as I mentioned in the position paper, all these formalisms are really useful tool to actually, if you want to take a specific piece of legal knowledge, then you will surely have to go to all of the formalisms that you mentioned if you want to formalize it correctly. That I don't deny. And the theoretical aspect of the AI law research has been invaluable in this aspect previously. The critique I was trying to make is that, so usually in the research field you have the theoretical branch and the applied branch, and you have discussions between the two. And this is, I think, while the theoretical side of AI law has been really strong with all the contributions that you mentioned, I fear that the applied research aspect, where you confront those theoretical pieces of contribution and to the real world and actually try to develop new industry standards, is where the focus has been lacking. And the critique I make in the paper is that I think that the way that the applied branch of AI law has been framing their goal is what's preventing them from penetrating more the industry and the market. And and you said this doesn't match the way you experience AI in law research, and perhaps that's because you were maybe more in the theoretical aspect of it. I approached it with a very empirical and practical aspect, and I went to the field and I went to those administrations that are doing their daily task of doing AI and law, and unfortunately they don't have any of the good theoretical contributions. They don't use any of them. And they're still in the Stone Age, right? And I'm saying, wow, why hasn't there been this penetration that would be beneficial to everybody, actually? And this is where I started to dig in and try to come up with this explanation, which I put forward in the position paper, which I don't claim is the final explanation, because of course the development of a field of research is like a very complex process that may be multifactorial. But at least I want to like spur up the debates and maybe having your opinion on that, because at the end of your answer I still couldn't find a conflict between us. So, but maybe there is no conflict. Maybe we're just approaching the same thing from different angles. I don't know.
So if I understand, Giovanni, if I understand correctly, Denis's point is that the theoretical work is excellent, but there is very little relation with the applied research. And I'm going to ask you a question, Denis, to clarify. I remember you sometimes told me that much of the applied work in the academic papers concerns toy examples. And yes, could you say something about that in relation to Giovanni's point?
So this is, I mean, especially for AI applications, a lot of them look good on toy examples, and the scaling up effect is where difficult things happen. But I must say, this is the reality for a lot of research domains. A lot of things work on toy examples, but when you try to scale them up, that's when the real problems arise. And I come from a domain which is program verification, where we have the same problem. There's a lot of theoretical work being developed on toy examples that seems to work really like a charm, but then when you try to verify a program that's more 50 lines of code, you start to cry, and lots of PhD students are crying because of that. And this quest of what does scale up is, I think, one of the main things that needs to be investigating when you're doing applied research. And this is the concrete applications that you mentioned in your response. I didn't see them deployed on more than toy examples, or at least because I don't know where these things have happened.
Okay, thank you very much. I think that I agree with you, Denis, in the sense that I was considering a bit what I've been doing all these years, and I found very little successful application, especially in the domain of symbolic. I've been focusing on symbolic AI, and I must say that I never did anything that had substantial real impact. I had some applications recently in the domain of machine learning, where it is much easier to develop something that is practically successful. But why is it the case? I don't know really. It's a bit, but it is a fact that if you look at the leading research on AI and the law, there are what we already have. What we have now as application are just some rule-based expert systems that are make use basically of a general rule-based engine. There is one commercial rule-based engine which is now Oracle Policy Automation, which was originally built on a legal program, on a legal project, which is called Soft Law, was called, and then it was after some steps that it has become
about Oracle, they're used at the French Housing Benefits Agency, and I haven't heard only good things about their actual use in that real world setting. But yes, I know really well what the Oracle thing that you're talking about.
Yeah.
Okay.
The other an example of an application which has been to some extent started in the law, then it become more general, and it is used to build this kind of rule-based expert systems. But this is not where research, this is not a domain for research, because this is a kind of standard technology being deployed in the legal domain as for other business rules. And there are recently, I don't know, Floris maybe is going to speak later of an application that is developed which make use of some more recent research, practical application based on argumentation. This is an interesting line of research that is being recently developed. So, and then, but yes, it is really a problem that we did all this kind of theoretical work, and it has not yet been translated into into real applications. We have to see what happens in the next years. I'm confident that this transition will happen to some extent, but I agree with you. And we may wonder what is the reason for that. Maybe we need to be patient and something will come up. But I think that the impact on the real world of research on AI and law has not been, at least symbolic research on AI and law has not been significant, very significant so far. More success for the machine learning-based approaches in various domains.
Thank you
so
very much,
this is
Giovanni. I especially applaud the word patience here, which in the accelerationism that surrounds machine learning, I think is a very beautiful term. And when you think of the call for humility that has been made, they sort of align, I think. You are going to get the floor, but I think that you are going to get the floor right now for your own presentation.
Okay, thank you. Okay, so my presentation will be in a way a continuation of what we have been just discussing together with Denis. It will be based. I wanted to give you an account of research on AI and law, and in particular research on AI and law and argumentation, starting from my own experience, so that you can have a view of how this kind of research developed. I take myself as the example until the current times, and that the question is what use can we make of this kind of research also for building useful tools supporting lawyers' activity. So I think I have 10 minutes. So without further ado, I try to share my screen, if I'm able to do that. Choose to share. I don't know, how do I share the whole screen?
I think we will get some advice, Giovanni, from the technical people.
Share. No, I think I may have done it. So just a second. I may have done it. I just need to go into the. Okay. So you should see my screen now. Do you?
No, we don't. So somebody is walking to the technical people and will come back. Did you discuss it during the testing? How to share the screen?
Okay. I think I say that I'm sharing here, but I don't know.
Okay.
I can stop sharing, but maybe I have to. Sorry, maybe I have to do something here. Audio output, video source, screen. Okay, screen share. I think I did it. Let me try again.
You are sharing the wrong screen, Giovanni. What that means, I don't know, but.
Sharing the wrong window.
No, okay. I think I'm coming now. Okay. Share. Okay. Is it working?
Absolutely. Thank you.
Perfect. So the idea was that I show you I hear a noise. I don't know why, but I hear some noise behind. Maybe, okay. So this is a bit going to be my story, how I started in the 80s to be interested into computational law. Then I started dealing with databases, a bit of programming. Then I had a law degree, and then I discovered computing logic. I had a master in computing, and I went into legal theory, and there I started also to work on argumentation. My first discovery in the computer domain while I was doing my PhD was logic programming, which enabled me to put legal content in a way that was immediately processable. You can build a program and make queries and get answers. But the first innovative thing that I tried to do together with my colleague Henry Placken was to move into the feasible reasoning. And this leads me into argumentation. So we observed that in the law, often you get to a conclusion, but then you may have reasons against that conclusion that prevail. So even if the grounds for a certain conclusion are present, you may have to abandon it. And this is the feasibility. There are logics for the feasibility, but no, I'm not moving on this. Okay, there are logics for the feasibility, but we didn't find that this logic useful. And so we made the move into formal argumentation. What is formal argumentation? We considered that the feasibility in the law, the fact that you may have an argument for a conclusion and then an argument for the opposite, and the second may prevail, preventing you from reaching the conclusions that was supported by the earlier reasons, can be linked to the idea of argumentation, that is a reasoning process that is different from the reasoning process that you have in logic, because in logic, when you have certain premises and you can infer a conclusion, if you add further information, the earlier conclusions remain valid. But this is not the same in law, we noted. In law, you may have an argument, and then this argument may be defeated by further argument. You may have preferences between arguments. You may have argument why you are having these preferences, and so you build a kind of architecture of argument, counter-argument, argument about preferences, argument why another argument is not applicable. And this is the interesting thing. At the same time, when in the legal in AI and law, we were reasoning about that, we discovered that other researchers, in particular Vietnamese researcher Pham Minh Dung, had discovered a logic for argumentation. Basically, the idea is that when you have conflicting arguments, you may have a way of assessing what is the outcome of these conflicts. So it's similar to logic in a way. Logic doesn't tell you the truth of these premises, but it tells you that if you have certain premises, then you can reach certain conclusions. And if the premises are true, also the conclusion should be true. And with argumentation is similar. Argumentation logic doesn't tell you what arguments you should have, but once that you have a set of arguments, and a set of arguments may be about those arguments, why one is stronger than the other, why one is applicable or not, you are able to determine what is the outcome of this kind of interaction in a formal way. By looking only at the structure of the argument and the way in which they interact. From this kind of approach could also be applied, sorry, let me see if I can move the screen. I don't know, sometimes, no, okay. It has also been moved into arguing with cases. So cases can also be seen as arguments, and you can consider a single case, but also clusters of cases, and develop arguments that are focused on the notion of coherence. And this leads us also into modeling the idea of presumption, burden of proofs. Another aspect that came into the research on argumentation was the idea that we have rules, but we have also values, and these rules promote or demote certain goals that are important, certain values. And therefore, the issue is to determine how the significance of values and of the extent to which they are advanced has an impact on the rules and whether or not you should apply rules. Further development of this research on argumentation is the idea of argumentation strategies. How do you choose an argument? Why should you go for one argument rather than another when you have limited resources? And this is another line of research. Another line of research is probabilistic argumentation. What about the cases in which you have doubts, you are uncertain about the premises of your arguments or the strength of the argument themselves? How can you reason on that? This is another line of research that I tried but have not yet developed sufficient respect. And argumentation in interpretation, this is connected to the aspect that Denis was stressing. So in the law, we can have in a legal expert system, usually you have a single interpretation that is inputted into the system, but there may be different alternative interpretations that have to be taken into account. So, and according to different interpretive canons or principles. So the issue is how do you reason about interpretation and move from choosing a certain interpretation to endorsing a certain substantive conclusions. So in the recent years, I have also engaged in the attempt to link argumentation to some kind of machine learning approaches, in particular to the idea of having classifications. In particular, trying to link case-based reasoning and trained classifiers. There is also an interesting development now to try to use argumentation to explain the outcome of machine learning systems. These systems are opaque, and the issue is whether we could rely on argumentation to provide an explanation, an understandable explanation of the outcome that are provided by these systems. And then another line of research in which is also linked to argumentation is the idea to try to connect somehow argumentation to the working of machine learning system and also of large language models, which is at the center of so much experience, so much research and interest, and also application today. I've also recently developed some application in this domain, which apparently are successful, more than some research that I did on the past, some attempt to implement symbolic systems as I did in the past. So I stop here, yes.
Oh, okay, yeah.
So this is a kind of overview of what I've done so far. And now the question that is the issue is what shall we do of this kind of research in practical applications in the legal domain, where, as we said with Denis, we have so far some rule-based expert systems that are very limited, and this kind of research has not gone into legal practice yet, while there is this new trend with machine learning systems, which appear to be successful in supporting lawyers in multiple ways.
Okay, thank you, Giovanni. Thank you very much. I'm going to give the floor to Natalie, who's going to reply.
Well, thank you, Giovanni, for that lovely presentation. And I want to thank you also for taking my YouTube recommendations in an entirely new direction, because in the absence of the paper, I spent a good portion of the weekend watching your previous presentations. So I have something sensible to say. I've been really interested in what you had to say, and it's clear to me, at least, that argumentation, if I've understood it correctly, argumentation-based approaches are clearly preferable to black box approaches driven by sort of data-driven NLP, particularly the kind of meta and content data-driven tools that are deployed by Lex Machina, etc., because you are able, using those tools and technologies, if I've understood, to provide an explanation for why the decision's been reached. My overarching worry with the research agenda is that, given that the incentive structures that are driving the direction of the discipline when it comes to application, that the types of approaches that you've invested such a lot of time in researching will be overlooked in favour of approaches that are perhaps more scalable in terms of time, space, and cost. And I'd be really interested in your reply to hear from you if you have a perspective on what sort of regulation is needed to support the adoption of these approaches in preference to other approaches which may be more opaque. I'm also really interested in finding out a bit more about, in the research that you've done, how closely the explanations you've identified for how these tools reach decisions would map to our understanding of a justification for that reason, because the type of explanation that is required in a legal system, it's not just, oh, what factors did I consider in why I reached this decision, but why? And that justification, when you're thinking about judicial decision making, can be taken from a range of things otherwise. So I'd be interested in hearing more from you on that. I also think the work that you've been doing on combining argumentation with large language models is really interesting to me. And I wondered how closely the elements that you've identified with trained classifiers mapped those that are produced by more traditional forms of kind of legal analysis, because I think understanding where they differ and where they don't is really interesting to me. I suppose in terms of thinking about taking the research forward in an applied basis, other than looking at kind of what regulation could encourage the development of the discipline in the direction that you've gone in, I'd be really interested in how the types of approaches that you're arguing for can take account of changes in social preference over time. So obviously standards, norms, attitudes evolve, and how that can be kind of built in to the discipline. And I think one area that's often neglected, but something that I've been really interested in my own research, is the public acceptability of because it seems to me that the strongest argument for the approaches that you've taken are that you can provide a superior explanation to other tools and technologies. But I wonder how people feel about that in practice and how people respond to it, and how much your approach improves trust and confidence, that improves the trust and confidence that people have, because in that approach versus some of the other kind of tools and technologies that are out there, because it seems to me turning the discipline in favour of the direction that you're interested in, being able to argue to funders and to policymakers that actually this type of approach is really preferred by the public because it confers really important rule of law benefits like maintaining public trust and confidence, would seem to me to be a really helpful tool in your arsenal in driving that forward. And I suppose that the final question is how you would consider the outputs of, where you consider the real benefits to this type of research being applied in practice. I thought it was really interesting in Denis' research, which I totally agree, is that this idea that tools are just recommendations until they're not, the way that we've created this. So lots of the tools get round carve-outs, get round the provisions in GDPR and others by saying, oh, actually, we're not decision-making, don't use this for decision-making, we're just advising you on the course of decision to take. But when you're thinking about scaling those tools, and particularly to people who don't have legal expertise and can't evaluate the outputs of those tools, then the fact that it's advisory, it's a distinction that doesn't really mean anything in practice. So I'd be interested in the practical applications. That's a lot of questions back to you, so I will leave that there, but thank you for being interesting and engaging.
You only have 3 minutes.
Thank you very much, Natalie. So I'm going to be quick. So let me start with, I think that argumentation is the best way that we have to provide a logical model of legal reasoning, and also to provide explanations. Obviously, argumentation has to face the so-called logic representation bottleneck. In principle, we can provide arguments why a certain conclusion holds, why a certain rule is to be applied, with what effects, why we should prefer it, but we need to have the information in advance into the system for the system to be able to perform. So probably machine learning approaches, I think that also Floris is going in that direction, can be used to provide the input to an argumentation system, in particular to match the rules in the system with the facts of particular cases, which is something that logic cannot do. Concerning the connection between machine learning and argumentation system, I think that ideally we should have a combination of the two. Machine learning system be used to provide inputs to the argumentation, and then argumentation being used to explain the outcome of machine learning system. But this is something, this is a project that has yet to be accomplished. So now we have the amazing results that you can obtain through machine learning systems, and I think argumentation has to try to cope with these results. But there is a lot of research in trying to use argumentation in combination with machine learning system. The idea is, the main idea I think is to have outcomes. You have two ideas. Either you integrate the two systems. For instance, I have a system that applies certain rules, traffic law, traffic rules, or rules on benefit to facts, and you have the machine learning system that extracts from a narrative, from a document, the feature that trigger the application of the rules. Or you may have a rule-based system, machine learning system, and then independently for it, an argumentation system provides an outcome, so provide an explanation for the outcome that you obtain through the machine learning system, and then is also a way of having a critical perspective on the machine learning system, because if you cannot explain the outcome through arguments, then it means that there is something that doesn't work there, at least according to our human understanding. So I think that we have to work on that, but it is a challenge for the future on which I don't have answers, I think, now. I must say that I have been surprised myself for how well this new machine learning system, in particular the large language models, work, and on the symbolic side, we still have to cope with these recent developments.
Giovanni, I'm very curious, when you say that you're surprised that these systems work so well, how do you test that? How did you test that?
I don't know. I was involved in a project where we used GPT-4 basically to make abstracts of decisions in the tax law domain, and we are going to process all 1 million of decisions in the Italian tax law, and the outcome are really excellent. These summaries, we had a test with humans, and in 90% of the cases, the lawyers said that the automatic summary was fine, according to them. So there are really, in certain tasks, it's really amazing as also conceptual search is something where this system perform really well, at least according to human judgment. Yeah.
So the Dutch Belastingtelefoon, that's the Dutch service that we have when you have a question about Dutch tax. You can call a number where law students can do some practice, and it turned out that less than half of the answers you get are wrong. It's an official phone number from the tax department. You cannot actually reach the tax department itself in the Netherlands. You have to call them, and if they think it's complex enough, they might give you the number of the right person. But if I understand you, the solution is close.
No, but it's a different application. I think our application is based on doing just linguistic work, making a summary making summaries of decision using only the information in the decision. So it is not. I think it's a different task from the task that you are considering, where you are asking the system to provide you legal advice based on all the applicable law. So I think that it depends on the topic. Certain things are good. Also, automated translation is excellent excellent now, I think. But it depends on what these systems are required to do. There are certain tasks in which they excel, I think, other tasks in which they perform poorly. Fortunately so, no, I think.
Okay. I'm going to open the floor with regard to all three presentations and the replies to the audience. To you. We have a mic somewhere, so if you have a question, please come forward. Yes, Flores, the floor is yours.
Thank you, all three of you, of course I can say a lot about the discussion between Denis and Giovanni on AI and law, but I will say something about that field myself later on today. One interesting observation I made here, and also during the discussions we had over lunch with some people, is that, and maybe I'm interpreting your slide in the wrong way, Natalie, but you say focus on simple technologies that give people access to justice instead of these fairly complicated, it said no argumentation, right? So fairly complicated legal reasoning, deontic logics, all that kind of stuff. That's maybe not where you want to put the focus if you want to build simple AI, or not even AI, just digital access to justice. Is that right?
Partially, I think one of the challenges is that in the hype that we've seen around large language models, AI, ChatGPT, that a lot of the earlier research in AI, where it could have kind of clear and more explanatory sort of power. I guess my concern is that a lot of what my general point is that the tools that are being developed at the moment map poorly to the actual problems that people experience in trying to access the justice system. And what we tend to see is where you look at innovations are developing, it's either a lot at the front end. So how can we either divert people from the justice system, or how can we conversely, help people file more cases without looking at the impact on the right as a whole? For example, there's very little work that's being done about, what's the role of technology in improving enforcement, or particularly in practice, like how do we make sure that that people receive decisions that are in accordance with law? How do we develop tools that can effectively balance inequalities of arms between parties? And I suppose what I'm trying to say is, following Denis, that my observation on the research field at present is that it's insufficiently matched with the problems that people experience. And that's actually a function of the fact that our huge, colossal neglect of research that actually tries to understand people's experience in accessing the justice system, where they drop out, and what the factors are that experience their problems. So my general observation is not necessarily that we need to focus on one type of tool over another, but that we need to make sure that we've clearly defined the problem that we're trying to fix in the correct terms, because the definition of the problem should direct the solution. And at the moment, it's all about the problem is being articulated as one of we need to reduce cost. And that's a completely different problem to the problem of trying to solve for access to justice. Does that make sense?
Yes, that makes a lot of sense. Can I ask a quick follow-up question to Denis? So that I think that's a very interesting reply by Natalie. But then coming back to what one of the things you said, Denis, and also discussed with Giovanni about the lack of connection to practice, maybe that's the right word. You said, for AI and law that's true, and that's also something that Natalie's now again saying. But I think it's true for AI at large, right? Of course, we have the ChatGPT, but can any of you? I mean, just look through the natural language processing, right? Look through the ACL proceedings of the last 20 years and tell me which of these things have been directly implemented, right? And where they have been directly implemented. Of course, it's going maybe towards practice, but still, the problem is still that research is generalistic, looking towards the future, not trying to solve the direct problem of the day. So how do you see that kind of tension, and would you argue for any kind of AI research to be more, or any kind of research to be more focused on practical applications, or how do you see that?
So you're right to point out that this problem of missing actual practice is a problem that's shared by, I mean, most research in general, and especially in the CS research. There's, and especially the field I come from, I'm guilty on all counts, and I mean, I've developed software that is too theoretical or unusable, etc., etc. But what I think the problem is that if you don't differentiate the theoretical research from the applied research, and if you mix all of these together, then the theoretical problems start to merge with the actual problems, or they stand as proxies for the actual problems. And I mean, it is true that it is a problem shared by the broad field of AI, and I think that LLMs will have applications, and there will be niche of applications, and for some contexts, they will be useful working tools. Of course, there's the hype cycle, so here we're at the maximum of the wave where everybody wants to use LLM for anything, but in the end, there will be like specific niches where it's actually useful. I think that's our job as researchers, especially applied researchers, is even though we are at the summit of the hype, to try to locate these niches and try to prepare when the wave will be coming down, so that there is actually something left after the wave and not just rubbles from funding disappearing all at once.
No, if I can follow, sorry, yes. If I can follow up on that, I think that what Floris, sorry, there is some noise. What Floris said, I think is true, that we need to wait between research and application, but I still feel myself a bit frustrated by the fact that so many things I've been working on in this year still have not found significant application. Maybe it will be in the next future. I'm confident that in connection with as the use of machine learning systems increases, argumentation as the logic for explaining their functioning will become more and more popular, and we are going to have also substantive applications in the legal domain, but not yet, I think.
Can I suggest what somebody called the 3 Hildebrand questions? So you can look at things from 2 perspectives. You can say, okay, we're doing very interesting and very important fundamental research into formalizations or argumentation, formal argumentation theory. And from that perspective, I can build this application, and I'm going to look for a problem that matches this application in the real world. This is not something new I'm saying, you probably know the argument. So I think we should always, before we talk about applied research, we should always answer 3 questions. What problem does this application solve? Not what it says it solves, but what does it actually solve? Second question, what problem does it not solve? And let's admit that many times the problem that is not solved is the problem that we actually have. The third question is, what problems are created by the real-world deployment of this application? So instead of saying, oh, let's do a cost-benefit analysis, before you do a cost-benefit analysis, you have to unravel all the assumptions about what is cost in terms of what, utilities, preferences, who is going to decide what is cost and what is a benefit, benefit for whom, etc., etc. So I would propose, and I'm looking forward to your responses, especially the speakers, but of course anybody in the audience, that before even thinking about a cost-benefit analysis, we should always ask the question, what problem is solved, what problem is not solved, what problems are created.
I can try to answer to that. Yes, of course, these should be should be answered. I even think that these should be maybe touched upon in engineering schools, where like the prevailing view towards innovation is that first you should do it and then after you should like think about what it's doing. But I mean, it's also rather than inciting the own people to think of that themselves, I really invite people to actually look out for the critics. Because the people that critique you, well, you may not be in agreement with everything that they say, and sometimes it's far-fetched, or this is a very theoretical concern. But you kind of recognize some valid points in the critiques, and especially in the points made here by the CRCL crowd. And I see that as some kind of a guide, when you're developing some innovative software, if you don't take into account both the critique and also the techno-optimist aspect, because you have to be motivated to create a technological tool at some point. You have to try to navigate between those two, I'd say.
Yeah, I was thinking of Natalie's argument that before testing whether we are actually enhancing access to justice, we first have to define what we mean with that. And if we're actually solving a problem of short-term efficiency, we might be leaving aside the real problem. So it is important to decide what is the real problem, and I actually don't think that's up to a computer scientist. In a sense, it's not even up to a lawyer. We are in a democracy, so we have to listen to what are the real problems. We need participation, not even of users, but before there are users. User is a very technocentric term. We're talking about citizens here, for instance, just an idea. And I think the paper of Natalie demonstrates this. If you are focusing on the wrong problem, then you can test it for accuracy, you can even test it for precision, and you can explain what it does based on inputting some symbolic representation, explaining machine learning if you're creating a hybrid. But that's not the point. The point is, what is the problem that is solved here? And is this application going to help with it? And in that light, I understand her statement that sometimes very important, and somebody is closing, oh no, I have to sit closer. That sometimes very simple, non-technical solutions, there's no money for that, because all the money is going to data collection and building models. And it would be interesting for this community, or the communities who are working on that, to raise these questions and to think about it, and to take a different point of departure, not what would be interesting in terms of your own research, but what is needed and how can I cater to that?
But can I, sorry, no, please, Natalie.
Well, as I think you've articulated what I was trying to say in a much better way, so I'll hand the baton on to you. I think also the question you raise over who gets to decide what a good is a really important one, and I think if you contrast the use of these tools in healthcare versus how it's thought about so my background, I started off my career in public health research when I, like Giovanni, was much younger than I am now. And within public health research, you have fairly established models. Like if before you even put together a research proposal, you need to consult with patients and the public, and you need to demonstrate that you've done that. And all the way through, you need to build in participation from patients and the public. And the reason for that is because it's recognized in medicine that if you want people actually have to want to use, if you're interested in solving for public health, people actually have to want to engage with health services. Whereas within justice, we're looking at a profession that's profoundly paternalistic, that has extremely tightly circumscribed roles for public participation. I mean, juries are perhaps the best and really only example, and then it's within tight limits. And I think one of the big challenges here is how do we upend that culture and make sure that it's not just a senior judge or a senior policymaker who's driving the direction of the discipline and driving the way these technologies are deployed. Because the risk is, if you override, justice systems are an important part of our democracy, they operate on consent, and if you override the views and perspectives of people, citizens, users, in the way that the field is developed, you risk undermining trust in the technologies, but also trust in the justice system. There's a lot on the line here, and I think how we kind of democratize the way in which the problems are framed is actually a really important question, and one that's kind of we don't pay enough attention to in this field compared with others, I would say.
Thank you. William Lucy.
So I'm sorry about raising this. This is a kind of really quite parochial concern, and it's about access to justice. And while I'm heartily in favour of your sentiments, and my heart is with you, I think what you've just said about barriers to access to justice residing in the judiciary, possibly, and removing barriers to access to justice, depending on the inclinations of particular judges. I think that's fine, and I don't disagree, but I think one thing we have to accept about our jurisdiction in the United Kingdom is that it has been a hostile environment for access to justice since at least 2007 or 2008, right? And it's not judges and lawyers who are getting in the way of access to justice. It's the austerity agenda of our elected representatives and the economic choices they've made as a result. And they are the barriers, in effect, to access to justice, yeah, that we're living with now and people are suffering from now. And computational law and recourse to IT and all the rest of it could solve that, but it could only solve that if it can also make up the budgetary deficit that has been ongoing since 2007, that was exacerbated in 2012, and we're still living with. So I guess it's not really a question. It just feels like we're fiddling while the United Kingdom burns. If our solution to the access to justice problem in our jurisdiction, it might be different in other ones, depends on one or other app or one or other IT system or something like that. So I accept that sounds rather critical. It's not of your paper because I think our hearts are in the same place. It's just that I think this problem's much bigger than this supposed solution or possible solution.
This is a question to Natalie, or?
It's Natalie mainly, but I don't think the other folks are talking about something as possibly parochial and tedious as access to justice in the United Kingdom.
I'm afraid more jurisdictions have this problem.
And Natalie, sorry, I can't put a question mark on the end of that because really it wasn't a kind of question mark, was it? It was a gripe.
I guess what I was trying to say in the paper is that, and I do start by saying this, that we are part of the reason why people are reaching around for technological solutions is because of this historic underinvestment in these. It's the case in our jurisdiction. It's also the case around the world. I mean, I think it was research that said approximately 5.2 billion people live outside the protection of the law on a global scale, and there is not unlimited public funding for justice. And I guess this is my broader concern, is that when people talk about the development of digital technologies and apps and tools, often the rhetoric they use is, oh, this will increase access to justice. But because we haven't invested in a proper kind of theoretical or empirical definition of what we mean by that, or where the challenges are, then access to justice becomes synonymous with there not being enough money for the system that exists, and that's undoubtedly part of it. But what that means is the solutions are always framed, if we could just make the justice system cheaper, we would fix access to justice. And I'm not necessarily And once you've accepted that the problem is we need to make the system cheaper, which I refute strongly, then, because I don't think just making the system cheaper would actually resolve the problem. In fact, it's not really even linked to the problem question. Then that framing of it's about making things cheaper, it affects the types of technologies you're interested in. It affects the type of cases you go for, and it has very little to do with solving the very real problems that affect people when they can't access and secure their rights. So I think, my heart is with you. I don't think the way in which technology is being positioned as the solution is accurate, because I don't think we've got the problem right, or at least those in charge of the system have got the problem right. And what I was trying to argue for in the paper was a wholesale reframing of the problem that looks more directly at, okay, well, what do we actually mean by access to justice? Where are the barriers? And then on a realistic, what are the problems that technology could solve within that problem, and what are the things that it could not? And I think, but until we've got the articulation of the problem correct, we're always going to land on the wrong solution. Is that helpful?
So, no, you should have it over coffee, which is coming closer. Only Natalie then has to be flown in telepathically to do this. There are two more questions. I just want to make one remark that in the paper that I already mentioned of Narayanan and Kapoor on the optimization of predictive AI, they talk about the value construct. So if you want machine learning to do anything, to predict anything, you have to transform a value, and that's not necessarily a simple value. But in this case, access to justice, you have to operationalize it, you have to find a proxy for it, a proxy that is sufficiently amenable to be translatable as a task for your system. And I think we're now talking about that, and I could imagine that computer scientists get bored because they say, well, just tell me and then I'll start formalizing or I'll start getting data. And I think it is very important that we are here today and tomorrow to get that conversation going, after which everybody goes back to their own domain, hopefully with realizing that just getting something, formalizing it, turning it into a task, and then doing the fun thing, scientific research, is not going to be enough, because just like the law, computing systems are now infrastructure, and they're actually critical infrastructure. So like lawyers have to take an oath, we're coming towards a moment when certainly the people who develop tools that are on the market, should maybe take something like an oath. Maybe the impact of these systems is bigger at this moment than the law. Lyria.
Hi, so Lyria Bennett-Moses, UNSW Sydney, and I'm also going to be a little bit parochial, so this is all from Australia, but I don't know if you've come across an organisation called Justice Connect, Natalie, because they've done they did start with access to justice. They did a lot of empirical work with what they call the missing majority. Their point was that at the top end, people can afford lawyers. At the bottom end, there's sometimes legal aid, for people, and there's this sort of missing middle. And they did a lot of work, and it is exactly that point about we're missing some of the simple stuff rather than building the more complicated tools. So their big example is, the first problem is that when people have a problem, they go to Google. That's actually where they start. They don't have the particular application that some amazing computer scientist has built. They're probably not going to find it unless it's on the first page of Google results. And their sort of related point to that was that people don't actually know they have a legal problem. So they're not looking for a computational law tool, because whatever their problem in their head is, my landlord's not fixing my tap, whatever it is, they're not framing that in their mind necessarily as a legal problem when they're looking for, what do I do next? So that, I suppose if you start with access to justice as the goal, in a genuine way, not in the, sort of efficiency cost cutting way, then you end up with very different questions about where computer science might need to look to solve that problem.
Thank you. I think Geneviève was first, and then, okay.
Thank you very much. Very briefly, thank you, Natalie, and thank you, everybody, for a great expose. What I just wanted to highlight in terms of the research agenda to which Mireille was referring, even when you would triple, quadruple, quintuple the budget for legal aid, your remark, Natalie, that we should democratize the way problems are framed for adjudication is highly relevant and is to the core of the paternalistic system that needs a reform. And that's independent of well, do we have enough budget, yes or no? That's what I wanted to point out to.
Thank you. The lady with the green dress is first, excuse me, with the green dress, and after that, and I'm sorry that I do not recall your names, but you will introduce yourself.
Yes, my name is Ola Aghtib. I was wondering about the question of problem framing, right? Because I do see the point of that machine learning usually is sort of propagated as being more cost efficient. But I was wondering if we turn it around. So, for example, if you look at fraud detection, then even a lot of fraud detection systems are usually, or at least with my limited knowledge, there are also fraud detection systems that are rule-based, so that then human officers, or at a screen level officers, if you want, they construct a rule, like, for example, I don't know, if your last name is so and so, then you're more likely to commit fraud or something. Just very fictional.
Alas not.
Yeah. But if we would turn, I mean, usually when they do that in a rule-based fashion, then there are all sorts of biases. And isn't also the idea that if machine learning would only be as progressed enough, and also the data collection, I mean, that then we could take away those biases, because then we could predict where the fraud is actually happening, so that there are not all these feedback loops in the fraud detection system and everything. I think that.
Okay, it's more objective, perhaps. I'm going to take the second question also, and then give the last word to the panel, so that we do have some coffee.
This one's for Natalie. It's actually for everybody in the room. So the Child Poverty Action Group did a big report on universal credit in the UK, and they took Bingham's 8 rules of law and tried to assess if universal credit applied to it. Essentially what they're looking at is the unhappy path to the design of user credit. So what happens when things go wrong? And it struck me that we use service design as a discipline that focuses on the happy path. How do we make sure people can do stuff? And data structures that we use are also designed. And so I then said, well, have our service designers and data specialists and technologists trained in the rule of law? So I started asking in Scottish Government, cross-government Slack, on apolitical, and the general feeling is that none of them are trained to think in terms of how does this system conform to the rule of law. So in the criminal justice system, are the people working at MOJ trained in that? And has anyone else seen evidence or done any training of the technical trades that support state administrative systems that shows that their developers know anything about the rule of law?
Yes, please.
I'm so pleased. So I funded that work in my previous role, and I'm so pleased that it's getting the traction that it deserves. I think you hit on a really salient point. And one of the challenges, of course, is that it's often the government isn't building these systems itself, they're devolving it to the private sector, who undoubtedly, I mean, rule of law, we talk about it a lot as lawyers, but it has, one of the horrible impacts of the low levels of substantive legal knowledge, that it just doesn't, if you said to the average person in the street, what does the rule of law mean? It wouldn't come up with those principles. So I think the need for training is really important. I also loved, Lyria, a big fan of the work Justice Connect has done, which is based, and a lot of the things that they've done have been looking at using the Spot legal tool, which I think was developed by Stanford, to how do you how do you help to identify people's legal problems from plain language text? And the point about Google being the front, like when the first place people go when they have a problem, being Google, it's so well made. My concern is the impact that ChatGPT will have on all of that, because increasingly we're becoming aware that people are turning to ChatGPT rather than Google for when they have a problem. We know that the way that those general purpose models return information, they don't necessarily select jurisdictionally relevant content, they don't necessarily select the most accurate content, and they're not opaque, they're not transparent about where that they return their content from. And that creates a real risk for users. The other thing that's really sad, so the Legal Design Lab at Stanford, led by Professor Margaret Hagan, is doing some work looking at how real people engage with that content. And the sad thing that she found, the thing that really breaks my heart, is that when they were asking people, how do you use that tool? How do you evaluate the information? Because it's presented in such a superficially attractive way, and people are just so completely desperate for authoritative information. The fact that it looks authoritative means that they don't actually want to know if it's correct. But unless we get a grip on this, and get a grip on this now, it has this huge potential to disrupt, the whole legal information ecosystem that lots of foundations and governments have invested a lot of money in trying to put high quality rights-based information online. But ChatGPT completely blows all of that out of the water, because as you alluded to, if people don't recognize that they've got a legal problem, they go to ChatGPT with a general question, then it returns stuff that's not relevant to them. So I think definitely thinking about, how can we solve for this? What's the regulation that's needed? The problem is, Morel and we're talking about this need for patience. And I think this horrible, the hype plus the huge issue of the fact that in many jurisdictions justice systems are crumbling due to underfunding is creating a perfect storm where no one wants to wait, and they're instinctively attractive to things that look superficially attractive without thinking about their wider impacts.
Thank you. I'm going to give everybody...
Can I, sorry.
Yeah. Go ahead, Giovanni. Okay, Giovanni.
Can I,
yes.
Okay, if I can just follow up on that. On support to justice, on support to justice, I would just, and also the use of language models, I've just been working on a project, this is not really support to justice, but the task is providing all judicial decision in tax law online for citizens, each one with a summary, which is constructed automatically, so millions of decisions, and also with some kind of semantic search, so that you just type your problem and you get cases out. So this is maybe it's not a solution, obviously, but there are some little things such as this one that can be useful. I also wanted to make a comment on this issue of the machine learning versus rule-based systems. I think that we need to distinguish systems that are used to make in a heuristic way, to make kind of factual forecasts. Is this person likely to commit a fraud, from the system that include a representation of the law. This kind of factual analysis, I think, can be done through machine learning or predictive system, machine learning systems. Ideally, we should be able to use a system where the model is understandable, that generates rules or something similar. But sometimes the best performing models do not have this feature, and then we need to control the outcome of the system, possibly using also a kind of argumentation system that is based on rules, maybe extracted automatically out of the functioning of the model. But this is a kind of complex interaction. What I want to focus is that when you have a system that applies the law, then a human representation of the law maybe I think is always preferable. When you have a system that makes factual forecasts, maybe relying on machine learning to a certain extent would be an appropriate choice.
I want to add to answer Ola's question that, of course, if you train your machine learning model, then you're incorporating the bias of the training data you've been training on. Additionally, usually administrations don't want to make the model public with which they select the persons that they're going to investigate the fraud, because they said, oh, if we release it public, people will game the system. So because of that, you have little way to actually check whether the model has bias or not, which kind of defeats the purpose. Another point I wanted to make is that those models, they're highly political, and the way fraud cases are being investigated is highly political. If you look at the tax systems, there is some public data for the US, which Saralowski has been reporting on, in which you can show that the state does not optimize its revenue, because it's known that the best investment for the state is to pay a fiscal inspector to concentrate on high-worth individuals to inspect their tax returns, but they don't do that. So this is also a case where there is more than the optimization and the efficiency. There is also some political factors that may be obscured by the throwing out of technology name dropping happening.
Okay, thank you very much. Just one remark and then we're off for the coffee. Giovanni, you're saying that predictive AI is doing very well, but okay, it's sometimes difficult because we don't have the explanation. For me, then the question is, how do we know it's getting things right? And I'm also very curious how this relates to the paper by Narayanan and Kapoor on optimization of predictive AI, where they basically conclude that it does extremely bad. So it hardly comes above tossing a coin. And the very complex models with I don't know how many parameters, they don't do better than a model with only 2 criteria very often. So I was a bit surprised that you're so convinced that this is all operating very well.
No, I was focusing on a specific application in which I've been involved, that is making summaries. This is not predicting the outcome of future decisions. I agree that making prediction about the outcome of future decision is very difficult, and we have no system that works decently in this domain. I think also because you must predict also the outcome of the assessment of facts. It's not just a law that is involved in the judicial decision, but also facts have to be assessed as well. Now, I was just focusing on this kind of project. I've been working with making summaries and making conceptual searches over databases of judicial decisions. And my experience was that in these tasks, summarization plus a conceptual search, the outcomes are good. But this does not entail that are good in other domains, such as in predicting the outcomes of future decisions, where I agree that the outcome so far are quite bad.
Okay. Thank you very much.